The procedure for the renewal of a French commercial lease is very formal, and failing to comply with its precise provisions can often have expensive rip-off consequences for the party involved. Sharp care on either side in drafting the content of a notice served by bailiff and other documents, as well as compliance with the time frame, are crucial. And the sanction of non-compliance is that the whole procedure could be declared null and void, triggering cureless consequences about the lease agreement. The lease is automatically renewed for 3 years under the same terms and conditions if none of the parties notices the other within 6 months before the anniversary date. The increase is based on the national index, such as the INSEE. On the 9th anniversary date, the lease is either renewed for 3 more years or for 9 years if the landlord fails to notice the tenant. If the landlord intends to offer a renewal of the lease at modified rent, he must give the tenant notice and set out the proposed new rental in the document served by way of notice to quit. If the tenant is not willing to accept the new rental amount or to continue the lease, then pursuant to the service of a notice, he would normally quit the premises at the end of a 9 years term without compensation. If he accepts the terms, then the renewed lease would be pursued for a further period of 9 years on the same conditions as the initial lease. If the tenant accepts the renewal but challenges the amount of the new rental amount, he is authorized to remain in the premises upon initial rent. But the most diligent of the parties must then file the case before the higher civil court. There is no right for either party, and particularly the tenant, to vary the terms and conditions of a renewed commercial lease, and the only issue which may be brought before the court in such a matter is that of the rental amount increase. But there are many opportunities to negotiate such modification. That being said, if a specific written agreement is not reached, then, with the exception of the rental amount, it is exact the same conditions of the original lease that are applicable to the renewed lease. The final rent will be set by the rent committee, ruling besides the district court. If during the course of a 9 years term of the lease, the tenant has not complied with the terms of the lease, for example, non-payment of rent, then the landlord may serve notice to quit without an offer to renew the lease at the end of the term. It is generally performed as a sanction. And according to French laws, the tenant who complies with the terms of his lease has an absolute right of renewal for a further 9 years period of time to the end of a 9 years term. So, if the landlord wants his property back, he must pay considerable compensation, indemnité d'éviction, to do so. The judge might end up ruling upon the amount at the compensation based on the tenant's turnover. During the course of the litigation, which may take a number of years, the tenant remains using the premises, but the new rent will apply retrospectively from the date of the landlord's initial serve of claim.